All right, well, it's 11 o'clock on my laptop, so I guess we'll get started. Hi, everybody. My name's Rebecca Shaw. I am the Executive Secretary for the State Records Committee, and today we're going to go over the GRAMA appeals process, dealing with getting requests, how to answer them, and the appeals process, and then we'll go over just a couple of the decisions the committee has made this year. So, I can see the chat, so if you have any questions, some thoughts, you're welcome to unmute and interrupt me, please. I am happy to have a discussion because otherwise it's just going to be me droning on. And if you got questions or anything, you're welcome to unmute and ask. You can put them in the chat. I can see that, and hopefully we can get a bit of a discussion going because the law can seem very dry, and I'll do my best to make it interesting. But speaking of dry, that's the first thing. We're going to go through a couple of definitions, and then I'll try not to have it this boring. But there are a few definitions that we don't cover in the GRAMA certification test very much. So I wanted to go through these because they're really part of this process. An access denial is defined in law, and so it's when you deny a request in whole or in part. And that can include redactions. You can provide a record and it can be redacted, but that still means there's a partial denial. And they can appeal that if they want. And I'm getting ahead of myself. So, appellate affirmation is when the chief administrative officer, the local appeals board, or the state records committee affirms the denial, upholds the previous denial. An interested party is someone who is not the record requester, who is aggrieved by the denial or appellate affirmation, and it doesn't matter if they actually participated in the proceedings. Although, when it comes to the State Records Committee, we definitely need notice, and I believe the CAO needs notice as well, that there is a third party interested in the case. A local appeals board, we'll get into this a bit later, is an appeals board that's established under 63G2 701. And that is what some entities can have in between the CAO appeal and the State Records Committee appeal. And I keep saying CAO, but I haven't actually said what that is, have I? The CAO is the Chief Administrative Officer, and we'll go into that in a little bit too. The record request is defined in law. It means a request for records, but under 204, so 63G2 204, it goes into all these different parts that have to be a part of the request. They need to tell you their name. They need to give you an address, a mailing address, an email address too if they want, and a daytime phone number so you can reach out to them. And a description of the record sought with reasonable specificity is what it says. And we'll get into this in a little bit, but that's a record request. And then the record committee appellant and the requester are just different terms for the person who's asking for the record in different parts of the process. So when they're asking for a record, they're the requester. And once they appeal, they are an appellant, right? So here's a really quick run through of the appeals process. And I've skipped the local appeals board because most agencies don't have one. So first you have the record request, and this is going to be answered by the appointed record officer. And so if you have somebody, if you're the one that answers all the record requests, then you should be the record officer. If you're not, I recommend talking to your chief administrative officer, talking to your RIM specialist or at the archives. And so this is the person that has a lot of responsibility for records management at the agency, and they work with the archives to help manage your records. When you get a request, please take a deep breath. It's going to be fine. And it doesn't need to be scary or intimidating. You have a lot of backup. You have a lot of help. If you ever have a question, you can reach out to me. There's a government record ombudsman who is there just to help you out and to help the public out with this process. You also have your RIM specialist and you have your colleagues. And so you're never doing this on your own. You also have legal counsel, I hope, that you can reach out to when you have a question. One thing that would really help with record requests is knowing your records. And I've seen this done differently with different agencies. Some agencies are really small, and so it makes sense and it works to have one person who is dealing with all the records management issues and answering the requests. And it works. They can actually physically get to where everything is. Other agencies are a bit too big for it to be practical to have one person carry all that responsibility by themselves. They can't actually do it all by themselves. And so one thing I've seen with a couple of agencies that I thought was brilliant was there's one record officer who works with the archives, and they are the ones that are answering all the record requests. However, they have their own little records management team. They have SMEs, subject matter experts in different sections of the agency and different divisions, right? And so they meet, those are the people they reach out to and say, I have a record request for this. Will you talk to your group about seeing if anybody has these records, or these records are up for destruction at the record center. Will you make sure that this is correct? And so they have their team that they work with for records management issues and records requests. And it works really well for them. I think that's great. Excuse me, sorry. Need some water. I'm talking a lot. And then, so for your chief administrative officer, this in the law is the person who is responsible for the records management of the agency, and they appoint the record officer. And they're not required to be certified like record officers are, but it would be a great benefit to the CAO to have some familiarity with GRAMA so that when they get an appeal, they understand what the options are and what the classifications are. And so if they also understand the records, that would be great, especially since one of their responsibilities is the records management of the agency. So, anyway, when they get the appeal, they need to check what is appealed. Sometimes the requester isn't appealing everything. Maybe there were just a few redactions and that's what they want addressed in the appeal, and they're fine with everything else. And so it's just check what's being appealed. And then one thing I'd really want to drive home, especially for record officers, an appeal doesn't mean you did anything wrong. It's an option available to the public so that when they are denied records, they have somewhere to go if they disagree. So, and you may be correct, and the chief administrative officer will deny it, and then they'll appeal to the state records committee. Again, take a deep breath. It's going to be fine. It's not a court. We are not a court. A lot of people treat us like a court. We're not a court. The committee is made of volunteers, and so having a hearing before the state records committee, again, doesn't mean you did anything wrong. Your answer was wrong. It's just an option available for the public, and in certain cases for agencies, as part of the appeals process. And after the state records committee, you can appeal to district court. Okay, so let's get into the request. Let me double check that this, okay, cool. All right, my first tip is going to seem really obvious, but this is my big soapbox. Answer the requester. just please. And it doesn't even have, I don't even mean make sure you answer them and give them all the records. It's just acknowledge that you received the request and talk to the requester a little bit. When an appeal comes to me, so I'm a little bit jaded because by the time an appeal gets to the state records committee, a lot of times passions are running high and people are really upset. And it's particularly frustrating when the entity hasn't responded at all to the request or the appeal. When that happens, there will be a hearing scheduled. That's just the way it goes. But when you get the request, you can ask clarifying questions to make sure you understand what it is they're asking for. And although if you get a request, make sure it's actually a request. A question is not a record request. So if someone contacts the record officer, fills out a GRAMA form maybe, and says, I want to know why my street wasn't plowed in the last storm, that's not a record request, that's a question. But if they want to know about the snow plowing schedule for this neighborhood, then there's a record involved and it's a record request. I hope that makes sense, but there is a difference between the two. And so questions don't have that appeals process. Records requests do. Also, when it comes to answering the request, back to my soapbox, just real quick. GRAMA says under 204 4B to answer the request as soon as reasonably possible, but no later than 10 business days. You've got deadlines for answering the request and deadlines to answer the appeal for the chief administrative officer, but it always says as soon as reasonably possible. Don't bend over backwards and not do your other work at all because there's a request, because the request shouldn't be shutting down the operations of the agency, right? As soon as reasonably possible. Oh, and actually, real quick on this last one, the code, rules, regulations, and policies. Again, this is part of knowing your records. You may have programs that fall under certain federal statutes. You might have a ordinance or policy that governs a particular record or process that might impact how you can answer the request. So the more you understand your agency and the processes and rules and things that come into what you do and what happens to records, the easier it will be to answer the request. That's that one. And a quick plug for the Open Records portal. I don't know how many of you use this. If you don't, I recommend getting familiar with it. It's the law says it's another avenue provided for, or access point, I think it says, access point for the public to request records from government agencies. And so it's just a website that the archives administers, and the public can make requests and you can provide records through here. You can, and it can break up the request in parts so you can answer if there's a fee involved, if there are extraordinary circumstances. So you can partially deny if you have to and provide records. You also have the option of receiving the request, acknowledging it, but answering it outside of the portal, which is fine. But if you do that, there's a checkbox. You gotta make sure you check. Otherwise, we have these automatic emails that go out to let the requester know when deadlines have arrived. And so if you're answering it outside of the portal and nothing's happening in the portal, then the requester is going to get an email saying 10 days have come and gone and there hasn't been a response. GRAMA says you have this appeal right. And it might confuse them if you're already answering them outside the portal. So there's that. And to use the portal, you have to create a Utah login. It's called a UMD. And I talked to the administrator of the portal before I did this training just to think, is there anything in particular you would like me to share? And his thing is just make sure the email address you use isn't one that's shared with other people, because it causes a lot of problems when different people are trying to log in using the same login. And anyway, I'm not going to bore you with the particulars, but it becomes a problem. And you can get an email address for free from Gmail, Yahoo, Hotmail. You can create an email address just for this if you want to. And so anyway, to use an email address that's not shared with anyone else, and then don't forget that checkbox if you're going to answer it outside the portal. But yeah, this is going to be getting some revamping soon that we hope will. No, I'm confusing that with the public notice website. But yeah, you can answer the different parts of the request separately. and correspond with the requester through the portal, and it might be great. I appreciate the plugin, Amy. That's awesome that Amy likes the portal. And so if it also has options if you're the record officer that answers the request through the portal, but you're going to be on vacation, you're gone for a little while, it has options there so you can designate somebody to receive notifications from the portal while you're gone. So it's there for the public, and hopefully it makes answering requests as simple as they can be for you. So when you're working with the requester, here are a couple things to ask yourself. One, do you know what they're asking for? If you don't, maybe it's too broad, or maybe it's just you need some clarifying questions with the requester. Is the request complete? Does it have their name? Does it have their phone number? It needs to be a complete request to be a proper record request. So if it's not if the request for records doesn't describe the records with reasonable specificity, is what the law says, reasonable specificity, then it's not a complete request. And so we need more specificity for this request to be complete. And then back to some records management stuff. Is it a record? Is it your record? And there is a definition in GRAMA for what is a record and what isn't a record, and we dive into that in another training that would be great to attend if you have questions on some things that you have and whether or not it's a record. And is it something that's already available online? You can just refer them to what's online, and then that answers the request. And make sure to see what work and cost is involved. Are the records stored off-site? Do you need to involve IT? Do you need to talk to legal counsel? There's what is involved in actually gathering these records and providing it to the requester. And another quick plug. The public notice website it's so you can inform the public about meetings, right? But you put meeting minutes on there, the audio, things that were distributed at a public meeting. So if you have a request for records from a meeting, you can refer them to the public notice website if you've been keeping this updated, and then it's a great tool to provide some public records online. Okay, if the request seems too broad, it can be specific and voluminous. Voluminous doesn't mean it's not specific enough, although you can definitely ask them something like, hey, I understand you're asking for this, but it's thousands of pages, so I'm wondering if there's something specific that you're looking for, so that you can narrow down the workload and it not breaking your time, and they actually get what it is they're seeking. So a lot of times requesters aren't quite sure what to ask for, and so they'll have a really broad request because that's the best way they can think about what it is they're looking for. But you know your records, and so the way they've asked for this is just huge. And so you can talk to the requester and just say, I'm not completely sure what it is you're looking for, because this is a big request. And you can let them know that this is going to require X number of hours with IT, and it's going to be expensive. And so if you could narrow this down a little bit, maybe we can answer this faster. And so at this point, you should have an idea of what the classification is going to be and what cost there might be. If the cost is really high, you may want to require a prepayment of fee in part or in full. And so filing a record request is free, but you are allowed to charge for the actual cost of providing records. That's what the law says, actual cost, which does get debated sometimes at the state records committees. What does actual cost mean? And so, yeah, as you just kind of analyze what is involved in providing the records and see if the expense is something that is the actual cost, and you can pass that on to the requester. So once you have your records gathered, once you know what it is they're asking for, you've got your record and you can classify it. And is it something you can provide with redactions? Is it a lot of redactions so that really it just makes more sense to just deny the record request? And so take your time to do it right. I've got one story. There was a requester who wanted an incident report about a fight between some teenagers in their neighborhood. And so she went to the police department and said, I want a record of this incident. And so the police department, the person who was filling this record request said, all right, but there are minors involved, so I have to redact stuff. And she said, okay, that's fine. And they redacted the requester's child's name and address and information and left all the other information there. So the requester, what she already knew was redacted, and what should have been redacted was provided. So there were redactions made, but make sure you take your time to do it correctly. And if that means that you need to tell the requester you need a couple more days or extraordinary circumstances involved to go through and make these redactions, then you can do that. We'll go through the extraordinary circumstances in a little bit. Time is flying by. Oh my goodness. Okay. So some tips on the denial. I use templates like crazy for everything just to make sure that I check all the boxes of things that I have to tell the requester and the respondent when I'm corresponding. And so if that helps for you, especially if you don't get, or well, I guess either way, I was going to say, especially if you don't get a lot of requests, but it works either way, just to make sure that you, if you're denying the request, describe the records that are being denied, provide a citation, as specific as you can too. Don't say these are protected and so we're denying it under 305, because that has a list of over 80 things and they're not all going to apply to your records. And it just leaves requesters upset. So a citation as specific as you reasonably can would be great. And then their right to appeal to the chief administrative officer. And so again, if you have redactions, that is a partial denial because there are things that aren't public and they can appeal if they disagree. And so one thing I usually I see that works well is it just says, if you consider anything here a denial, you may appeal to the chief administrative officer at this address. You must appeal within 30 days. And that works great. Okay. Let's go through some extraordinary circumstances. There are 9 extraordinary circumstances in GRAMA. And I'm going to zip through these quickly because time is flying. So if another government agency is using the record, then there are 2 different things that fall under this extraordinary circumstance. One is you just need to ask the other agency for it, and you've got 5 business days to make that request and have them give you the record so you can give it to the requester. And so that's an extraordinary circumstance. But if there is an audit going on or something so that you can't actually receive the record because it would interfere with what's going on with the ongoing audit or investigation, then claim extraordinary circumstances and tell the requester when the record will be available. And then if the records are voluminous, it's going to take time. There are a lot of records involved. And the law says that to complete the work as soon as reasonably possible. So don't drop everything. Your agency still needs to function. But as soon as you can provide that record, that's what the legislature would prefer. So give them an estimate, and that is something that can be appealed if the requester believes that your estimate is unreasonable. And so that comes to the State Records Committee sometimes. And that doesn't mean your request is wrong or your claim of extraordinary circumstances is wrong. If there are a lot of requests at once from the same requester, and she's like, hang on, we received a request, but we're a little overwhelmed with the request that we've got. I think it says within 5 working days. And so you need to disclose that you've located the records, but you need time to do the work that is required. And again, as soon as reasonably possible to get through those requests and answer. Here we go. Also, if there are many requests, so it's not just from the same person, but you have a lot of requests going on. And so there's a lag, right? There's a delay. And so let them know when they can expect a response. And again, as soon as reasonably possible. If you have a large review, so you've gathered the records, you've got a lot of records, but you need to go through them to inspect them, do any redactions. There's work that needs to be done before the record can be provided. And so that's an extraordinary circumstance, as soon as reasonably possible. If there are legal issues, that one, you get 5 business days after the response time. So you have 10 business days, 5 if it's an expedited request, but you got 10 business days. You get an additional 5 for this if you need legal counsel. And then segregation gives you 15 more business days. I don't know where these numbers come from, but there are just a couple of these extraordinary circumstances have a specific number of days that you get, and others just say as soon as reasonably possible. So if you're segregating information, you get 15 business days from the date of the original request. So it's really just 5 more. I don't know why it doesn't just say 5 more like the last one, but that's, anyway, tangent. Okay. If you have computer programming that's required, you can get additional time for that, but that one's as soon as reasonably possible because systems are different and the time that you can dedicate to it is different. And so as soon as reasonably possible. And when you tell the requester that you're claiming an extraordinary circumstance, you need to let them know they have a right to appeal. And the first appeal always goes to a chief administrative officer. And I'm clicking the slide. Is it coming? There we go. So as we mentioned, the chief administrative officer is responsible for the records management of the agency. They appoint the record officer, and they need to receive the appeal within 30 days of the denial. And then just like the request, they've got 5 business days to respond if it's an expedited request, or 10 days if it's not an expedited request. And they can delegate this. They can have a designee that just deals with the GRAMA appeals for them and have that designee. That's absolutely fine. And the chief administrative officer has the option of using the weighing provision, which we'll get to in just a second. And so what can be appealed? If you have a restricted classification, so we didn't provide the record because it's private, protected, controlled, they can appeal that. If the record doesn't exist, they can appeal that if they disagree. A failure to respond is considered a denial. They can appeal that. A claim of extraordinary circumstances, if the requester disagrees or thinks it's unreasonable, they can appeal that. And then if they requested a fee waiver and that was denied, they can appeal that. A couple quick tips for the CAO is review the denial. What was the denial correct? Is there public interest? And then they've got, again, 10 business days, 10 days business days, sorry. They have 10 business days to answer. And if you're providing a denial, again, you need to describe the records, provide a citation. And then if mediation absolutely can help. Rosemary Cundiff is the government record ombudsman, and you get there are a lot of options that aren't really part of the formal process in GRAMA that are available when you're in mediation. And one other thing, there are confidentiality agreements. If there is a confidentiality agreement, okay, if there's a confidentiality agreement involved, then the CAO needs to let them know, right? And you need to, when they receive an appeal, they need to notify that interested party, right? They're basically an interested party that there's been an appeal, and you have 12 days. I think it's just days, not business days, to respond to the appeal, because this is kind of an extraordinary circumstance, because there's another party that needs to be aware of the appeal. And the chief administrative officer has the option to use the weighing provision. So they can consider the varying interests involved in the records and that are, in play in making the appeal decision. So the records can be classified, protected, private. They could be properly classified. It was correctly denied. But the chief administrative officer has the option, has the discretion to decide there is enough public interest that we should release this, even though it was properly classified. Okay. So when you get a request that's not really an option, you're classifying the record, but the chief administrative officer can say it was properly classified. However, there's a lot of public interest, and so we're going to release this. For example, say there's a closed meeting and you have a requester asked for records from the closed portion of the meeting. And so it was denied because those records are not public. And the chief administrative officer decided there's so many people that want this and the media is asking. I think the public interest outweighs the interest in restricting access to the record. And so the response would be the records were appropriately classified. However, using the weighing provision, we've decided to release this. Okay. Before I keep going, do we have any questions? She covered the requests and the CAO appeal. Is there anything she has want to ask before I plow forward? I'll give you a minute to type. Is there a time limit on how far back people can request a record? That's an excellent question. There is not. They can request anything they want, right? Whether or not it's going to be provided is different. So there is a great benefit in maintaining your records according to retention schedules when it comes to GRAMA, because for example, I saw a request recently where someone was requesting a record from 2016, and the agency responded and said, we don't have that anymore because according to the retention schedule, we keep it for 4 years and then it's destroyed. We don't have it anymore. And so it's far enough back, they can still request it, but it's not something you need to provide. That makes sense, because the record doesn't exist. Also, if you have the records, if it's so far back, it's a permanent record and it's now stored at the state archives, you can refer the requester to the archives for that record. But if you have the record, you should classify it and provide it or deny it, regardless of how far back it goes. It's also possible that the request goes so far back that it becomes voluminous, right? They're saying, I want everything from this date to today. And the farther back they go, the more records are involved and the more work is involved to gather the records, right? And so there may be an extraordinary circumstance involved, but they can request whatever they want. Does that help? Does that make sense? They just might be more involved in answering, and there may be an extraordinary circumstance involved if they're going back far enough that it's going to take more work to find it because it's not something you're actively using. If you have records stored at the state record center, then those records are still in your custody. They're just stored off-site, right? And so the record center can send back the box or scan back some of the, we have a scan on demand program at the record center. So if there's something that you need that's stored there, then you can contact the Record Center and they can help you out with that. So I hope that helps. Did we cover where you can find both the Open Records portal and the Public Notice website? Oh, did we cover where? The Open Records portal. I don't know if you can see my screen. Can you see my screen? Nope, you're looking at the PowerPoint. If you go to openrecords.utah.gov, that's the Open Records portal. Let me see if I can just zip back to that slide real quick. Where are we at? There you go, Open Records portal. So there's a little login in the top right corner, and that's where you need to enter a Utah ID. And this also will send you a reminder to certify. And then the Public Notice website. It's under utah.gov, so I can send you the actual. Actually, let me do this. That's the Public Notice website, and then you can log in there and post notices for meetings and some public records. It's a great tool that you could use to provide public records. And if you have things that are online on your website, on the Public Notice website, when you answer a request for those records, you can just refer them to that link. And Amy asked, I'm curious how most people respond to those question requests. Do you deny it? Do you provide a document that will show them the information? Is there anything else? It just kind of depends on what you want to do and what the question is. So yeah, I'd be curious to see what everybody else does too. But the big thing with the difference, the only point I really am trying to make on the difference between those is that it doesn't have, when you answer it, you don't need to provide appeal information. It's not a record request, right? So you can answer the question if you want to, absolutely. And it's good customer service, right? Or whatever. And answer the question or refer them to somebody who could answer the question. When I get questions, I usually end up referring it to somebody else because it's not actually an appeal that I need to deal with. There's usually somebody else that is a public facing person that should be answering those questions. And so I usually pass those on. It depends on the question, I guess, and the person, right? Rebecca Abbott says if there is a record that clearly answered the question and they're actually looking for a record, they can provide the record. Absolutely. Yeah. All right, so real quick about local appeals boards. Under 701, it really just describes how to create an appeals board, a local appeals board, and what it involves. So some agencies, there aren't a lot that have a local appeals board. The law says it's 3 people, and it has the same appeal deadlines, right? So when they get the CAO denial, they have 30 days to appeal to the local appeals board. And there are 3 members. You have an employee from the agency, a citizen, and a records professional. And that's about all the law covers. So when it comes to how appeals are laid out, time limits for filing statements of facts and things like that, when the hearing is going to be scheduled, what a hearing looks like, that's really up to the entity making the local appeals board and the local appeals board to make their own rules on what that looks like. And so this is where, when the local appeals board makes a decision, either party can appeal to the state records committee. And I might have seen 1 or 2 appeals to the state records committee that are actually from a governmental entity, not a member of the public, but it's really rare because there aren't a lot of local appeals boards. So when the state records committee here's an appeal from a denial from the chief administrative officer or the local appeals board. And that's the next step in the appeals process. And when the appellant sends an appeal to the State Records Committee, they need to send the appeal to the entity the same day at the same time. So when I schedule an appeal, I do let them know that if they haven't done that, they need to. And then I review the appeal and schedule the hearing, or I have the chair review it if there's something that might be a denial if it's untimely. That's the CAO also has that option. If it's something untimely, if it's outside those 30 days, then it's it can be denied because it's outside that time frame. And 5 days before the hearing, the committee needs the statement of facts from the agency explaining what you want the committee to do, why the records were denied. And doesn't need to be a legal brief. We have a lot of attorneys coming to the committees these days. And it used to be, I've been attending hearings since 2013 because I'm a nerd that way. And I used to see a lot more record officers coming to the State Records Committee, but now I see a lot of, it's a lot of lawyers and attorneys. And so they're used to court. And so they'll send the committee this full legal brief. And I don't know how much work goes into those and how much time goes into those, but we just need a brief statement of facts, what you want the committee to do, why the records were denied, and, supporting statement. And then when you come to the State Records Committee hearing, you need to bring the disputed records so the committee can review those if they feel they need to. And here is the committee. There are 7 members on the committee, but there are only 6 at the moment. We have a citizen member vacancy that hopefully will be filled next month. So when you come to the committee, you have 20, both sides have 20 minutes to present their case to the committee, and then you'll have 5 minutes closing. And witnesses can be called if you feel that's necessary. We have had record officers attend as witnesses, which really helps the committee when they explain the process that they went through to see if they were responsive records. And then the committee can really understand the effort that's been put in to resolving the request. So we got 7 members. We have Marie Cornwall is a citizen member. That's the black and white photo on the top. The state archivist, and then a member of the media, that's Tom Haroldson in the top right corner. And then a representative from the Utah League of Cities and Towns, at the bottom center, that's Nancy Dean. A private sector representative with records management experience, that's Mark Buchanan in the bottom right. And someone with experience in electronic records and databases, and that's Ed Beeler on the bottom left. And he's from Bountiful. He's new to the committee, and so we're really excited. When something has been appealed to the State Records Committee, you can reach out to the Government Record Ombudsman and mediate and participate in mediation to maybe resolve the appeal without having to have a hearing. And that is it's great. In fact, okay, yeah, for the State Records Committee, they're going to review the appeal, review your statements of facts, and maybe review the records. They don't always, but they do review the records, especially if the committee's going to use the weigh-in provision and release the records, because even though they're properly classified, there's a lot of public interest, then they have to review the records. So also, when you attend the hearing, we are meeting in person at the Taylorsville State Office Building, but there is virtual attendance available. We're using Zoom. So we've been meeting, it's a hybrid now. And then the committee will deliberate in open session. So you'll hear their reasoning. And then the decision and order is drafted and sent out within 7 business days. And then you have 30 days to either appeal that to district court or to send in a notice of compliance. And then that closes out the appeal, right? Oh, we got a question. Do many people appeal a fee waiver denial, such as members of the media? We do get quite a few appeals for fee waivers. Sometimes it's a member of the media who says that as a member of the media, the fee should be waived because it's in the public interest. Sometimes it's a fee waiver because they disagree with the fee on principle. And other times they find that the cost is too high and that's why it's unreasonable. And so the committee can only determine whether or not the fee waiver denial is unreasonable. The committee can't actually say the cost is too high because they can't tell you what to charge. They'll ask how the fee was determined, but they can, they're really just making a decision whether or not the denial of a fee waiver was reasonable or not. So we get quite a few fee waiver hearings. Yeah, it's a great question, Mary. And so mediation is an attempt to resolve the appeal without a hearing, right? And both parties have to be willing participants. And so there's a lot of there are times where one party is willing to mediate and the other is not, and that's fine. That just means that the committee will hear it. And the mediation is confidential. What is discussed in mediation is not before the committee. And you can have a lot more possibilities to resolve the request rather than just a decision about whether the classification was right, whether the denial for a fee waiver was correct. You get a lot more options. And Rebecca asked, so you don't deal much with appeals about the fee being too much? We do get appeals because the appellant feels that the fee is too high, but the committee can't change the cost. Does that make sense? The committee can't say this fee is too high, you should charge this instead. They can't do that. They can just say whether or not the fee waiver denial is reasonable. Does that make sense? So both sides will go into how the cost was determined, and the committee will ask if it's the per hour is the lowest paid person who can do the work, because that's in GRAMA. And did you charge for the first 15 minutes? Because you're not supposed to charge for the first 15 minutes. In fact, since we're here, I think I have a couple bonus slides here just for fun. So if they simply feel if they didn't request a fee waiver, but they simply feel the fee is too high, what are their options? So if you have a case where they didn't ask for a fee waiver, but then they were informed that there will be a fee, then they can appeal. Rosemary, are you on?
Yes, I am.
So if they don't actually ask for a fee waiver, they can still appeal if they think it's too much, right?
I think they need to ask for a fee waiver. If they didn't initially ask, then they get an estimate of what the cost will be, then they can go back and ask for a fee waiver.
Yeah, so if you had claimed like extraordinary circumstances and so you need more time, and so the fee doesn't even come up until you've looked at the work that's involved, then they could ask after that point. Rebecca, did you?
Yeah, so my question is, we currently have an appeal that we'll be discussing tomorrow where we have fees established in ordinance for a specific type of record, and they believe those fees are too high. So they did not request a fee waiver, and it's not anything we established as in looking at the volume of the request or the work involved in the request. It's just already established by our county ordinance, and they believe it's too high. So do they have the option to appeal that?
They have the right to appeal an unreasonable denial of a request for a fee waiver. but they really don't have the right to say that the amount is too high. So, I mean, it's kind of a backdoor way of getting at their opinion that the amount is too high.
Yeah, a lot of times when they say the amount, it's like the way they're asking for a fee waiver is saying that's too much. It's a different way of asking for it. But if your fees are established by ordinance, and the committee can't tell you to change your ordinance.
No.
So,
Okay.
And in rare cases, when the amount is really exceptionally high, like I'm thinking of an example of the Kane County Water Conservancy District. There was a hearing, and the requester, Utah Rivers Council, had asked for email, and the Conservancy District asked for $7,000 to look for and gather those email. So the Utah Rivers Council asked for a fee waiver, and when that went to the committee said that the denial of the fee waiver was too high. Well, anyway, the committee sided with the requester, and I think that the reason they did that is because that seemed like an exorbitant amount for what was being asked for.
I'm sorry to digress here. I know you could have a conversation offline if we need to move ahead with the presentation. So, but I'm curious what the public's remedy is, because of course we want due process, but what is their remedy if they fill our ordinance that has been passed and it's in our ordinance that we've got down, got online? Do they have a remedy to say you're charging too much for that? Would that just be through court?
Well, it could be through court, but they could also go to the county commission or the city council to complain.
Okay. But it's not necessarily an appeals process through under GRAMA.
Right. I mean, I don't think the records committee would overturn any ordinance.
Okay, thank you very much.
There have been cases where the committee has said, what they think. Like we think that we're surprised that they're charging this much per hour, but it's not an unreasonable denial. They have done that where they what's the word I'm looking for? Where they kind of provide a little commentary, but
right, there are a couple of instances where they've provided commentary, like they said that the law means the net pay and not the gross pay, including benefits. That's one of the committee members made that suggestion, and the committee went with it. In another situation, they said the cost was too high because they charged somebody for faxing, and it was so much page for faxing, and they could have just emailed it or emailed it, and that would have been cheaper. So they decided that the requester didn't have to pay the cost of the fax. But no, I don't think the committee, my opinion, would ever overturn a city or county commission's ordinance.
Yeah. So too. So when you come to the hearing, both sides will present. The committee might look at the disputed record. Sometimes they will continue a hearing just so they have some time to review the records, because that's a lot. And then they might ask questions, and then they'll deliberate and make a decision. And after the hearing, you'll receive the decision in order within 7 business days. And if the entity is ordered to provide the records, then you've got 30 days to provide the records and send the committee a notice of compliance, or let the committee know you're appealing to district court. And either party can appeal the committee's decision to district court, but that's got to be done within 30 days of the date on the order. And then anything that is appealed to district court can't be remanded back to the State Records Committee, except that's actually been changed. So it can if the court will only remand issues if it's something that the committee hasn't discussed or before, and it's in the best interest of justice, which is legalese for it's in the it's the court finds it necessary to send it back to the committee. And so with the 5 minutes we have left, I want to just highlight just a couple of the cases that we've heard this year. And this one actually we we will be hearing again tomorrow. So Rosenstein's the petitioner, UDOT's the respondent, and they requested all records related to this particular company. And so UDOT initially said that the parties were involved in a adjudicated proceeding, and so the records didn't need to be provided because the Utah Administrative Procedures Act prohibited discovery, and that means they also don't need to provide the records through GRAMA. And the committee disagreed and said GRAMA and discovery are very different processes. A public record's a public record, and so they need to answer the request. And so this one was continued 6 times because the parties, there were a lot of records involved, and so the parties were working together to go through the records and resolve the request. And the respondent needed time to gather the records, classify the records. And so the last time that they came to the committee, we were down to these 2 big binders of records that had been classified as non-public for one reason or another. And so the committee is reviewing those in camera. And so they're reviewing those before tomorrow's meeting. And hopefully tomorrow, the committee will deliberate and this case will be closed unless someone appeals to district court. And so
I just want to say this request was really way too voluminous.
it really was. Because the respondent didn't make that case to the committee didn't consider it. So it's okay to have more than one argument when you come to the committee so that you bring it to their minds and they'll discuss it. Another case, this is Tiffany Gilman versus Unified Police Department. Tiffany Gilman is an author, and she's been doing a story on Ted Bundy, and she wanted to write something about about Nancy Wilcox, who's missing person. She was last seen October 2nd, 1974. And so she wanted the case file involving this missing person case. And it was denied because the case was considered active because it was not solved. Her body still has not been found. And so the committee decided to review the records in camera. And after Ms. Gilman's argument was that the case is really old and there is a lot of public interest, and there's so much known about Ted Bundy, but there's not a lot known about the victims, and they deserve to see the light of day as well. And so the committee reviewed the records in camera and decided that releasing the record would not interfere with the investigation or disclose investigative techniques because it's from the 70s and a lot of things must have changed since then. But so the appeal was granted, but it is subject to redactions so that if there's any name that is not known outside of government, that will not be provided. And Marie Cornwall is a sociologist, and so it was really important to her that the requester respect the victim. And so anyway, the deliberation was really interesting with that perspective, but the appeal was granted subject to redactions. And at that point, if the requester hypothetically disagreed with the redactions, she would appeal to district court because the committee had already heard it. And then for the last one, if I can click my slide, there we go. Mark Allen, the petitioner, Utah County was the respondent. He was requesting text messages between the county commissioner and 2 other people involving the Bridal Veil Falls, and maybe some development. There's a lot of public interest about the development of Bridal Veil Falls. And Utah County said that the records didn't exist and that they do not maintain the cell phone communications of its employees, and that includes the commissioners. And the committee found that the text messages are records subject to GRAMA if it's government business in their government capacity, they're records, even though they're text messages. And there was a little bit of a commentary there as well, that there should be a higher standard of transparency, especially with these higher officials. And the committee, but however, the committee was convinced that the respondent didn't possess the record because the record officer came to the hearing and explained her process and everything that she did to see if records existed and to obtain these for the request. And the committee was convinced that they had done everything that they could and the records don't exist. So that's those are just 3 of the cases we've heard this year. The committee is meeting tomorrow. And so if anyone's interested, I can give you our Zoom link. It's also on the public notice website. We're only going to have 3 hearings tomorrow because we had more scheduled, but some have gotten resolved in mediation, and so they dropped off the agenda. So we have 3 left that will be heard tomorrow. And one of them is this continuance with UDOT. We'll see how long the committee is in camera. If you have any questions with records management and your responsibilities as a record officer, these are the RIM specialists. And depending on what kind of agency you are is how you determine who your RIM specialist is. So if you have any questions, you can always email me, email recordsmanagement@utah.gov. And then this is my contact information. And if anybody has any questions, I'm going to stick around for a while and we can continue talking. Otherwise, thank you so much for coming. And I'm going to turn the recording off.